Good evening, everyone. I am delighted to welcome you all in today's webinar on topic Rights and Strategy on Operational Creditors. This is the 70th webinar in the series of webinar organized by IBNet, your own platform for sharing knowledge and experience on the IBC ecosystem in India. We are privileged to have eminent, esteemed speakers, Mr. Pratim Bayal, Ms. Suhasini Ashokbi. Both of them have subject expertise and practical legal insights in the topics. We can have a great learning and knowledge sharing. I extend my special thanks to Shri Ashish Makhijaji, President of IPNet, for bringing all us together on this robust IPNet platform. The membership link is available in that chat, and we look forward to those who are yet to join IPNet as the members. IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert-led learning incentives like webinars and study groups, practical guidance on IBC related challenges, and a dedicated member portal offering comprehensive resources. For those who are already member of IPNet, thank you for your support. For others, I encourage you to join this dynamic and ever-evolving network. Membership details are available in the chat. Thank you all for being here. Let's make this session insightful and rewarding.
Thank you, ma'am. Thank you for the brief introduction for this webinar. So I'll share the link for joining the membership shortly. And now we will play the IPNet intro video.
In the fast evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Good afternoon, everyone. I'm Advocate Ria. Sir has, I'd like to introduce Pratim Dayal. Sir has been a fellow chartered accountant, insolvency professional, and LLB with 25 plus of years of experience across corporate insolvency, stressed assets, banking and finance. A partner at Research and Solution Professionals LLP. He has led and resolved large CIPs, including Birla Tyres Limited, and handled cases with aggregate exposure of around 8,000 crores, formerly with ICICI Bank and Associate General Group. He's also a visiting faculty on IBC and with Pan India presence. We all welcome you, sir.
Yeah, good afternoon. Good afternoon, everyone. Ria, you and Shwashini madam and other madam and other competent fellow members we are having. Definitely, it's a great platform to interact with. Actually, I always call it a sharing of experience, uh, so that it's not a presentation that way. It's a sharing of experience which I have gathered all our fellow experienced people. And definitely this platform with all the initiatives from all across insolvency professionals across country, led by our respected sir Ashish sir, from whom we have got really good insights into the process at every step of the process. He has been helping not only us, very well number of professionals in this field. So with this, I'll start the presentation. I have made a small presentation. I'll go one by one slides. But apart from that, I'll try to explain whatever I have gathered during my few around couple of 10 CRP I have already completed. Two are going on. So that those things I just wanted to I'll be trying to communicate to you, uh, so that we can make a understanding what the issue is. So today I have been given a this thing. Just one second. Let me share. Shwashini madam, would you be sharing, or I'll share the this thing.
Share, you can share, sir. You can manage your slides. Or if you want me to share, I can also share.
No. Then let me share. That will be good because it will be easy to manage it. Just hold on. Just one second. Is it visible to everyone?
Yes, sir. Yes, sir.
Okay. So today I have a subject to discuss upon is rights and strategy of operational creditors discussion. Now this is a really vast subject, and really in some areas it is more subjective than whatever is written in the law itself. What I find, it is my experience that law is very simple, specific on these grounds, but there are a lot of process oriented uh, litigation discussions, controversy is there around operational creditors. Okay. Now first, I go to the rights. Now, um, in my slide, I'm just showing what is operational debt. Operational debt means, just to start with, operational debt means a claim in respect of provisions of goods or services, including employment along with interest. So, provision of goods, provision of services, employment is also taken as a service. For that, operational creditors includes workmen and professionals, workmen and employees, along with interest. So service and interest, these are the two area where we could be requiring some of the illustrations, that some of the discussions. So we have a right, the operational creditors can file an section 9 application. Okay. They have a right to drag a company into insolvency through an section 9 of filing. There is a demand notice that has to be issued under section 8 and all that. So I'm not going into detail, I'm just elaborating into rights. Then we will this try to discuss more on the strategy. Now uh, this then right to submit a claim under section 18 and CIP regulation 7 and 9. Operational creditor can file a claim with the interim resolution professional and resolution professional. This claim can be either operational creditors claim, or it can be a regulation 9A under other creditors. There are a provision of other claims that I will come, because why I am pointing out this thing. Now, operational creditors can file a claim in a prescribed format. That I think more or less it is known to everyone. And now we have regulation 9, regulation 7. If you read, that has a provision of giving supplementary document before the. It says like this: a operational creditor under regulation 8 or regulation 9 can file a supplementary document to the RP if something comes in, but before the formation of committee of creditors. But this is really not that much stringent. So provided that such person may submit supplementary document or clarification in support of the claim before constitution of the committee. So that is a right. We can file a claim when operation creditor can file a claim. And the timeline is the general timeline, 90 days from the insolvency commencement date, ICD, or RFRP date, whichever is later. Now, if there is a delay, these are the dates which is beyond the date publicized in the public notice for filing claim. So up to this date, we are allowed to file a claim with the RP or IRP, but we have to give a reason for the delay. Beyond that, also even RFRP issued it. Beyond RFRP issued it can be filed, but then this will actually take the claims to a court process. That is the RP will collate the claims which has been placed before the after the RFRP date. It will be placed in the next COC till the COC in which the resolution plan will be discussed, and then in that COC it has to be discussed with the other member of the already existing committee of creditors, and if they find it, uh, and the RP has to classify those by his own, what is the acceptable claim, what are the non-acceptable claim, and after that he has to file a petition with the note of the COC. He has to file a petition with the adjudicating authority collating all such delayed claim to the adjudicating authority for condonation of delay. This was actually made, I think, in around February 25 or something. This was actually made to lessen the burden of delay claim petitions on the adjudicating authority, because what has been seen that when a resolution when a particular CIRP process is approaching towards resolution, then suddenly there is a suddenly 2, 3, 4 claims comes in which are beyond the date of beyond the delayed frame, and those delayed claim keeps dragging the entire process. So that's why this was an attempt to collate all such claims and make a single application to the adjudicating authority. Generally it is allowed delay with an exception. So that's why RP will first make an suo moto judgment whether it is acceptable or not, then it will go to court. This is the process. Now these are the two rights which COC which the act has given. Now apart from that, I have what I do. There are two rights which I have not included. One is present to be present in the committee of creditors. So committee of creditors, if the total claim of the total claim of the operational creditors is more than 10% of the total claim, including the financial creditors, then a representative of them should be allowed to be forming a part of the members of the committee of creditors, provided they are represented through one particular person. So in some cases it might happen there are 100 of creditors whose aggregate claim comes out to be 10, and the total claim including the financial creditor comes out to be 100, and the total claim of the operational creditors, let's say it is 11 for the sake of simplicity. So it is more than 10% of the total claim. So in that case, the OC should be allowed to participate in the operation in the committee of creditors without any voting right. But in that case, what will happen? They have to come out through a particular delegated authority, so that every 100 members is not presented. One representing the entire set of creditors is presented. So this is a situation. This is also right, but it is not very common situation. But whenever it comes, it is a difficult situation to handle. Practically, it is a difficult. You have number of creditors. You have to at least inform them to choose a representative and be and present them in a committee of creditors without, definitely without the voting rights. But this is a really hazardous process, but it is process as it is. Okay. Now, this is one. Second is the operational creditors can form part of the financial member of COC with voting right. That is also there, but that is a case where there is no financial creditor. No financial creditor. So recently, uh, I was hearing a case before NCLT Kolkata, where it was a typically case. I am not going into the merit or this thing. I'm just giving you the statement of fact. In a claim size of 10 crore, suppose 10 crore 56,000, 10 crore 56,000 is the total claim. Out of that, 56,000 is from operational creditors, and 10 crore is from a financial creditor who later was recorded as a related party. Now, though that related party was excluded from the committee of creditor, and then so the committee of creditors, after exclusion of that financial creditor who found out to be a related party, uh, it uh, it um, it so happened that the operational creditors is 56,000 of credit or debt due, one being some financial service from this kind of auditor or something. They become the member of the COC with voting rights. So this is a typical situation. It happens. I don't say it is common, but it happens sometimes, and those things also becomes very difficult. And generally, those COCs become very defunct. You can't get support. You can't get nothing moves on. And those kind of things are there. But what I'm saying, by law, when there is no financial creditor, you can have a COC with the operational creditor being a member of the committee of creditors with voting rights. So these are the rights of a that way the say going typically by the subject. What we wanted to discuss is mm, this thing, what we wanted to discuss as rights of the operation creator. Now I will discuss about the strategy. Now strategy uh, is basically to how to handle the operational creditors. Okay, there are different kind of situations. Today, what I'll come to next slides of my this thing presentation. I have classified some of these things. One is a normal supplier of goods. One is a supplier of service, that is and typical service being rent and all that. And one is statutory things, and another is the workman and employees. Now, the statutory and workman employees are the most difficult position of a CIRP process. And to my mind, there are really there are some open areas, gray areas, and sometimes it becomes a very bitter experience to deal with the PF authority and all those things. So I'll try to analyze the practical situations, what happens with during a CIP process, and what is the legal position and now in currently, and where, to my mind, there is a deviation with the intent of the legislature. That is that I just wanted to talk. Now, let me bring out. Uh, one second. This strategy. Let me share the next slide with my presentation. Now, what I said that I have defined these are the subject I will discuss: suppliers, service of goods and services, tax dues, gratuity and claim from PF department. One of the most dangerous part of a CRP process. Minimum amount under Section 53 in a resolution plan, which is also has been repeatedly analyzed in different cases. Different body of adjudicating authority have classified, have discussed these things. The must clause in a resolution plan, which you must have so that your resolution plan does not fail. Then I'll give some typical practical experiences of running a project in an EPC company, how operational creditors in a project company has to be handled where there is an ongoing project. Then difficulty with electricity dues and the invoice, or interest implied in a supply invoice. Now see, supplier of service and goods. Now, supplier of goods is the most easiest part of an operational credit, operational credit system in a CRP. Supplier of credit, generally they will file claim. You accept according to the documents they have given, either the invoice copy and all that, those things. Sometimes they charge interest. Now, interest has to be contractually specified earlier, otherwise there is no this thing. And if it is only mentioned in the invoice, sometimes suppliers give invoices with an interest clause, but the position as far as I am concerned, only mentioning interest clause, a general interest clause in an invoice, does not make him liable, make him eligible for claiming interest. That is the position I am taking. But if there is a contract already which specifies interest, that is there. Otherwise you can take a interest as per negotiable section 80 of the Negotiable Instrument Act. That is there. Now, so this supplier of goods, the normal supplier, are easiest part to handle, apart from the personal peer issue that the creditors will call you, my mera paisa due hai, and all those things are there. But apart from that, you are well protected in the law. But in just mind it, in any resolution plan, keep some amount for the operation creditor depending upon the situation. Nil amount should not be given to any class of creditor, including operation creditor, including operational supplier of goods. So this is the basic thumb rule. I think most of you must be aware. Zero payment though it is not legally incorrect, but it is many plan have failed, or either it has come to COC, not fail, I say, come back to COC again, to put at least some amount to operation creditor. Now I come to this thing, lease rent, and leave and license fee. Lease rent.
I have one query, sir, regarding
Yes,
the disclosure in interest portion. So, can we add also a arbitration clause in case of dispute, and in case of invoice? If you mention the how can we do the MSME, as per MSME interest is allowed so and so percentage some type of disclosure? How can we make that disclosure?
No. If see, MSME is something different. If the company is under MSME, so MSME Act interest will apply. That is there. At least in the claim portion, if the company is allow, that is also there in my slide. So if it is under a particular law, that claim, that interest can be taken advantage of, at least in the claim portion. What I am
No, no.
talking about, the file.
My question is
Filing.
pertaining to disclosure in how to make a supplier protect his interest by making the disclosure statement in the invoices that the if
I
the
tell you, yes, I tell you the ideal system. Ideally, what you should do if you are an operation creator, whenever you are doing anything, any kind of transactions with a particular company, it is better to first formulate a terms of payment key. These are the terms of, before raising the invoice, it is most advantageous you form a one pager or two pager terms of payment. My invoice is this. We are allowing 30 days of credit. After that, within another 30 days, you have to make the payment with maybe zero interest or one interest, or if it is beyond 60 days, you have to make a 1% or 2% interest. Whatever is, if something is written agreement, that will take care of every possible litigation dispute. If you have instead of blindly mentioning in the invoice, now in the invoice you mention our interest clause is this, as mentioned in our contract, or even if you don't mention the contract reference, if you have the contract, that is the most ideal situation. Or if you are an MSME, you make a disclosure that our in case of delay in payment, the applicable interest under MSME Act will apply. This kind of disclosure will there. The language of disclosure is not very important. What is important? The basic underlying document pre-preparation. What I suggest, whenever we have a discussion, have a terms of payment defined, and get it accepted by the company. That will take care of the many issues that can be later on disputed, especially in the insolvency reason.
Yeah, and
Okay.
also save from the, if you add arbitration clause, then it will save from IBC sometimes, na?
Yeah. Arbitration, yes, yes. In arbitration law, what it says, even there are situations where without any mention, the arbitration can be initiated. Arbitration can be initiated even if there is no mention of in the terms of payment. But it is better that by theoretical law, Arbitration Act provides for oral agreement or without mentioning. But ideally, you should mention that the dispute related to payment can be taken to arbitration, and whatever you can also define the jurisdiction according to your office place. So mentioning arbitration clause is a well practice. See, these days a well drafted terms of payment is always available. Get it something very, make it simple. Generally all the legal documents are unnecessary huge, and these things huge is a sometimes it becomes a jugglery of language, apart from the rather than a common simple communication. So have 3 4 terms of payment defined, including the arbitration clause you are saying. And if you have any, if your organization is falling under a particular act like MSME Act or something, you can also mention that and get that accepted. Then even if you do not mention in any clause any such thing in your invoice, that agreement will take care of your right of interest from the principal. Okay.
Thank
Sir,
you.
there is one doubt regarding this. There is no MOU, memorandum of
Mhm.
supply, some conditions that agreement is not there. But the
Mhm.
invoice is raised with interest clause, and that is signed by the CD company.
Mhm.
So it
No,
is an
signed by the
acceptance.
city. No, signed by the city means to whom you are raising the invoice.
The invoice is raised on the company CD, and CD has
Uh,
acknowledged it.
then if it is accepted, then it is fine. If you have get a signed accepted invoice which mentions the interest clause, then it is fine, no problem. That clause is there. I'll come to that. Let us just
Okay,
discuss these points. That there is a separate slide. All these points are taken care of there. Okay.
okay.
So uh, so what I was telling, lease rent, though these issue I have not handled much in practice, apart from a couple of things in recent past. But I'm just trying to give you a situation. See, lease rent actually is not a service by the definition of operational creditor. Lease rent is actually you are transferring a right to occupy a space against some amount. So it is not actually giving some service. There is a judgment, Ravindra Reddy and J. Kishan. Rent arising from a pure lease of immovable property does not constitute operational debt under Section 521 of the IBC. It is transfer of a right to enjoy immovable property, and Transfer of Property Act applies. Okay. However, where the lease arrangement is composite in nature and involves provision of essential commercial services, in addition to the premises, tribunals have recognized such claims as operational debt. Suppose there is an agreement, you are given a fully furnished house, electricity and all that, even the security maintenance, those will be there. You are taking a consolidated charge. So then it becomes a operational creditor, and the definition of when once you are becoming an operational creditor, you will have a right what the other operational creditor is having, including initiating section 9 process. So mere lease rent for a space is not an operational credit. Uh, uh, Lease rent with some facility, like electricity, like furniture, and all those things, that becomes a operational debt. Leave and license generally happens. So leave and license is something different, where Indian Easement Act applies. It is permission to use premises, no interest in property. So there is no shift of interest in property. You must be knowing, in long term lease and all that, actually we sign a when there is a suppose we sell some property in lease, and the leasehold right, it has to be sent to the buyer, prospective buyer or a successful buyer. Then you have to sign a lease assignment agreement, and that actually will give the right on that land to that particular new buyer. So if the license is of composite in nature, involving fully furnished office, housekeeping, maintenance, electricity, etc., allied, so in that case it becomes operational creditor. Leave and license allied service is more common in nature and does not give exclusive transfer of interest in property, unlike lease rent. It is in general operational debt. So leave and license agreement is in general an operational debt, unlike pure lease agreement. So whenever, if suppose somebody you are consulting, he wants to know whether I want to initiate a section 9 application, I have a lease agreement. What do? So you have to go through the lease agreement. You have to see whether it has a fees which includes other fees like furniture, fully furnished office, housekeeping, maintenance, electricity, etc. If that is there, those are the service that is being supplied, and in that case, uh, it comes under operational creditor. So NCLT illustration, there is one case, Anup Sushil Dubey, National Agriculture Cooperative Marketing. Whatever I have discussed, actually it is saying something that, with along with some essential commercial facility, the transaction is qualified as service. Now, claim of EPFO, gratuity claim from employees. Now this is really uh, a difficult situation as of now. uh, in a nutshell, EPFO claim has a urgent, super priority, high handedness in the CIRP process as of now. Whatever the CIRP, and including the liquidation process, the employee EPFO department claims submitted by an EPFO department has to be paid in full, or has to be provided in full. This is the legal position, though I have some difference with that I am discussing. But in general, in a resolution plan, if there is a department, if a claim from EPFO department, your resolution plan must say that the claim submitted by the APFO department and the submission on the date of ICD, that has to be paid in full. The resolution applicant must take in full. So whenever you are an RP, you must see what are the claim position, what are the things that has to be given, and if there is an EPFO claim, you must start negotiating with the prospective resolution applicant that EPFO has to be provided in full, and you must make the lenders, the major lenders, secured creditors, banks aware that this has to be paid in full. At least the claim submitted on the ICD date. Anything done beyond that, that means there is a EPFO hearing, EPFO process is going on, assessment process is going on. ICD is on 1st January 2026. On February 2026, there is a claim determined by the EPFO department, and they file the claim. That is not accepted. We are only concerned with ICD, insolvency commencement debt, and we are only concerned with the priority is only on the amount of the claim, not on the penalty or interest thereon. That is also a well settled position, more or less. Or anything found out after the insolvency has started. But in liquidation also, before after the liquidation has been done, they cannot do any further recovery process apart from claiming amount from the amount to be distributed by the liquidator. They cannot do any assessment, and later on they find some during the after the liquidation started, they found out some amount, they determined some claim, and they refurbish their claim or resubmit their claim. That is not allowed. So whatever, there are two debt: in case of CRP, insolvency commencement date; in case of liquidation, liquidation commencement date. these two dates, but the amount which is there, you can see in the slide I have written, EPFO need not compete in Section 53 waterfall mechanism, SBI versus Mozarbeer. And more or less now, claim of gratuity has to be paid in full. JT Aerovet Maintenance Engineers Welfare Association versus Chowchuriya. Now, see what I'm telling. So a EPFO claim has to be paid and provided full in the resolution plan. Amount of claim by the employees of gratuity accrued and due up to the insolvency commencement date has to be paid in full. Okay. Now, gratuity is a variable function of salary. So if there is any difference in salary, suppose there is a case in one of my situation, what happened, there are a particular portion or particular period was a suspension, work suspension. Now that the CD has suspended the work. Now, so that salary was also not accepted because there was a suspension. If that salary was not accepted and there is a suspension of employment, in that case, the relative period, relevant period for that, what I say, the gratuity also would not be accounted for. Gratuity is a number of completed year of services. So what I'm saying, apart gratuity demand will come from the employees, EPFO demand will come from the respective department, and if there is a claim, valid claim admitted, you have admitted after verification, that has to be provided in full in insolvency or in liquidation. Now, what I say, the SBI case, SBI Motherware Kormuchi, they did not compete under Section 53. There are a lot of cases, and more or less NCLT and Supreme Court is nowadays this thing. The IBC does not override employee social security protection. Now, I am sharing my view why it is actually in number of cases, case law, if you see, actually they have taken the or mentioned the definition that the EPFO claim does not fall within the definition of liquidation estate. They does not come under liquidation estate. But this 3643 Act, this is the definition of liquidation estate in IBC. It says the following shall not be included in the liquidation estate and shall not be used for recovery in the liquidation. 36.4. Now, in that subsection 3 says all sums due to any workman or employee from the provident fund, the pension fund and the gratuity fund, these will not form part of the liquidation estate. What, to my mind, I think there are so many professionals who believe actually this was intended that if any fund is already there, if any assets are already there which is held for third party, means workman and employee, that will not come under liquidation estate. So there has to exist some fund which is already there, that will not come under liquidation estate, and that has to be used for complying with the workman liabilities or workman PF liabilities and employee PF liability. But in any way, the law stands as on that is like that. Suppose in a liquidation process, you have a claim of 15 rupees from EPFO, and you realize from the sale of liquidation estate 100 rupees. So your distribution under Section 53 has to start from 85 rupees. That means 100 minus amount of claim from the EPFO department of 15. So you 100 from 100 you minus 15, and this 85 then has to be distributed under Section 53 with work secured creditors, workmen, then unsecured creditor, like that. Okay. Now there is a gray area. You see the last point. What is the priority? Liquidation cost or EPFO dues? Now this is a area, but what we believe liquidation cost should get priority. So there are some situations where EPFO is saying even before the liquidation cost, including the liquidator fees, is given, because Section 53, if you see, the first point is the liquidation process cost, which includes the liquidator's fees. That has to be given. Then the and liquidation process costs include the unpaid CRP cost, and then the distribution towards secured creditors, towards workmen, employees will start. But EPFO is saying in some situations that this will supersede the liquidation cost as well. in any way, this has not been clearly settled. But what has been settled, that the distribution of section 53 will not interfere the claim from the claim from the uh, EPFO department, and this will not um even the gratuity also has to be paid in full. Gratuity claimed by the employees, that has to be paid in full.
Sir, what is
So
the
that,
regulation? Could you tell me what is the reference for this? Because PF dues ride over Section 53. Where is the guideline? Where is the
guidelines is the case laws. I am saying, you see the SBI versus Mozarbeer Karmochari. You see the Jet Airways maintenance. You see Satish Gupta versus Committee of Creditors in ISA Steel. So where everywhere more there are so many cases that
yeah, I got it, sir. I'm an advocate also. I'm an advocate. But there has to be a regulation na, from IBBI. There
no,
has
no,
to be
no,
a
there is no
regulation because so many
no, no.
cases are coming. So many cases are coming. They can form one regulation stating that the Section 53 is subject to PF dues. We don't know.
Yeah,
We don't know when latest we are referring some cases, sir. We don't know what latest case has come because there could be a latest case where the case the court would have told it is not subject to section 53 is not subject to PV of those. So instead of
yes,
leaving the liquidator to the vagaries of these court judgments, why don't IBA give a clear cut guideline stating that section 53 is subject to P of those? He's
yeah,
our regulator,
that,
na? Regulator should come because there
yeah,
could
yeah.
be so many cases, sir. There could be so many cases. You can interpret cases as per the context.
I
So
agree.
that is my last time also. I have brought to the notice of the madam also. Why our regulator is not giving the clear cut direction to the liquidator?
Yes, sir.
Yeah,
Because so many court cases are coming, sir. So many court cases are coming.
yeah,
Tomorrow
yeah.
we will
I
be
agree.
under litigation because there is no clear cut guideline from my regulator and leaving us
I
to follow court cases.
Yeah, I agree. I agree. So as of now, the regulation, there is no specific regulation, and I am not sure whether in the intended bill also something on that ground has been included. But as of now, there is no clear-cut amendment in regulation. In July in 2025, there are, I think, more or less seven amendment has happened from February to October, but there is no amendment till now including this, but it is definitely generally guided by the case law. That is the situation. So why IBBA is not doing that, definitely I am not in a position to answer. But you are right, there is no specific section on or specific regulation on this. We are only guided by this thing, but the problem is it is so hazardous for as the RP and all that. We have to, everyone is keeping this in mind, and in especially in resolution plan also we are keeping a specific provision. I'll tell you, I'll just show you what we are trying to keep in any so that it is because this is becoming a kind of mandatory section in in IBC that has to be complied with, though there is no specific regulation or section as of now. That is the situation. Okay, now so next this thing this
So I have just simple question that in case of there is a adjudication order, means order from the EPFO department after CRP commencement or liquidation, then we should not take cognizance, na?
Yes, 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 yes. It is up to the ICD date, or it is
Hmm.
up to the insolvency commencement date or liquidation commencement date. If something is adjudicated after that, you should not take cognizance of that. That is
Correct.
clear. No
That
problem.
is clear, na? That is clear. Okay.
Absolutely,
Thank you.
that is clear. That is clear. That is clear. Now,
Thank you.
it's a simple case study I've taken. Our transition group has a very beautiful cases website from where you can search something interesting. You can just keep on refer, or if you have any particular issue, you can just try to get relevant case law legal position on that. I just took one thing where this was the situation tribunal allowed. It was that the EPFO department come out with some claim which has, and they attached the assets of the corporate debtor. Okay, now in that case what was decided that um, uh, the tribunal directed that the fixed deposit, there was a liquidator has created some fixed deposit. I don't know the what basis they have created on that. Might be they have something in the mind. So that fixed deposit created by the liquidator for the amount claimed by the EPFO should be used for repayment of the EPFO's dues, thereby giving the EPFO priority over the stakeholders. The tribunal based its decision on the provision of 3643 of the IBC and the law laid down by the Honorable Apex Court. Now, why I took this took this case law, this is somehow is coming in my view, that fixed deposit, if something has been created towards a particular PF liability, that has to be separately set off with the PF department dues. It would not form part of the liquidation state. That is the legislative intent. I'm not going in detail of this case law. This is a typical this thing. But what I was trying to intend that this is a situation where I think legal entity, the legislative intent was complied with, but I'm not going into detail of that. But what was the basis of creating that fixed deposit? I'm not aware. What I'm saying, that fixed deposit, if some asset has been kept particularly for a particular PFO obligation, that has to be used. That you cannot fall under Section 53 waterfall mechanism. That was the intent of that particular case. Now, minimum amount that has to be kept in Section 53. This is very interesting. Now, I just read out the section. 32B provides for the payment of debts of operational creditor in such manner as may be specified by the board, which shall not be less than the amount to be paid to such creditors in the event of a liquidation of the corporate debtor under Section 53, or the amount that would have been paid to such creditors if the amount to be distributed on the resolution plan had been distributed in accordance with the order of priority under Section 53. So it shall be, so at least this amount has to be given. Achha, now, very interestingly, Section 53 1B says that the following amount, following dates shall rank equally between among the following this thing. Workman dues for the period of 24 months preceding the liquidation commencement date. This will rank pari passu with the secured creditor. So this clause sometimes is missed out in forming a resolution plan or something. See, if a CD has a claim from workman also. Now, who is workman, who is employee, that if you want, you can go deep into detail. There are workman definition. Sometimes it is state level laws that there is a minimum wages kind of thing. Otherwise, some level laws will be defined that what is the who are workmen. I don't have that much of detail in the workman definition, but workman is also a defined category. You can also go deep into that where there is a huge amount involved. So you can just determine who are workmen. Workman dues for 24 months preceding the liquidation commencement date is actually also a secured creditor as far as Section 53 is concerned. So their amount has to be protected as per liquidation estate date. So what you have to do, the liquidation value minus EPFO claim, what I said, the EPFO has a priority, and the liquidation cost. That amount becomes the eligible amount for distribution. Now, if that liquidation value, suppose the claim from the secured creditor is 80 and the claim of the amount of 24 months due from the workman is 20. So these 80 and 20 are ranking pari passu as far as Section 53 liquidation distribution is concerned. And this value, the liquidation value minus EPFO claim and liquidation cost, that you have to find out, and then you have to make a distribution of that, and that workman amount has to be protected in a resolution plan. Be very careful. This point sometimes is missed out. So we see in operation creditor, no, nothing, the amount they will be attributed to them is zero. So generally it is not, nothing amount is provided. You should be aware of that. In that case, you should make, if there is a labor heavy organization, you should make the assenting creditors or the secured creditor aware that, look, if the resolution plan restricts the amount to a particular amount, and if that 24-month salary is there, your kitty will go down. I'll just show one clause which we generally keep in resolution plan so that the resolution plan ultimately gets approved by the adjudicating authority. So what I wanted to indicate that this is the minimum amount that has to be paid, and workman dues for the period of 24 months is actually pari passu with the secured creditor. The must clause in any resolution plan for workman. This I just wanted to. This is my out of my practical experience, whatever I have little tried to know. So the regulation 38 says the amount payable under a resolution plan to the operational creditor shall be paid in priority over financial creditor. And there is one more thing: the creditors who do not vote in favor of the resolution plan has to be paid in priority to the financial creditor who votes in favor of the resolution plan. Now you see, this language is very helpful. If the amount to be given to the operational creditors on account of liquidation value payable to the operational creditor, including workmen and employees, in terms of Section 32 and Section 53 of the Code being higher than the amount provided in the resolution plan for the settlement of such creditors, then such amount shall be paid in priority. So suppose you have provided 10 rupees for workmen. Now, by that clause of which I mentioned earlier, by that clause, by being at par with the secured creditor, their minimum amount coming to be 12. So in that case, you have to pay 12. That 2 rupees, any such additional payment, which is the additional payment, 2 rupees, shall be proportionately deducted from the payment to be made to the assenting financial creditor, such that the total obligation of the resolution applicant does not go beyond the total resolution amount. This can be that way, or if the resolution applicant is if they want to take that risk, even that additional amount they want to protect the financial creditors who votes in favor, to just to encourage them to vote the resolution plan, they can say, I have seen resolution plan also. This is the in general term, but I have seen resolution plan where they are saying if the minimum amount that is coming under section, because resolution applicant is not aware of the liquidation value, they do not know, and they might not be fully aware of the amount that is the 24 months 24 months salary, which is at in par with the financial secured creditor, they might not be aware. So they in some plan I have seen, they write that any, if there is an amount, suppose that they have provided for workman 100 rupees in the resolution plan, and they say if the amount under section 32B comes out to be higher than the amount eligible amount provided for the workman, then the additional amount will be brought in separately. This kind of plan is also there, where the stake is higher, where the financial creditors are stronger, or stronger everywhere they are stronger, but one thing, they want to keep them they want to sure that the plan gets through, asset is lucrative, uh, they provide, they will try to understand the amount of impact that could come through a discussion with the RP, and they can provide separately. Otherwise, they can provide that additional amount will be deducted from the assenting financial creditor. So this kind, because adjudicating authority will ask whether section 50, that the regulation 32B is complied with, because that is the mandatory content, because adjudicating authority is always taking care of the legal compliance of the plan, nothing else. So they will see, and generally in every cases they see whether gratuity is paid in full, whether the section 53 clause is the minimum amount is protected. So for workmen, that is there because they are at par with the secured creditor. Other operational creditor, there is no problem. As I have said, normal supplier, they don't have any problem. And apart from EPFO department, the tax revenues also, you tell the RP, or if you are making a plan for someone, you put some amount for them, and do not make them nil, but generally normal, by seeing by the case to case basis, give some amount, and that will take care of, at least there will be no issue from the legal point of view. So this was my take on the resolution plan, this thing. Now or the minimum amount for the operational creditor. Now quickly I'll say on the running project in an EPC company. Now this is a very typical case. Suppose you are handling CIRP of an EPC company. In that case, what happens generally, what I've seen, I've done a couple of things. There could be one ongoing project. Now in EPC company, generally physical assets are less. The credentials of those projects are important, for which the company comes, any RA come, or that arbitration, someone was mentioning arbitration. In EPC company, there are arbitration awards for which also pending arbitration awards, those could be. So that also can make the EPC company attractive. Now what happens in an ongoing project, There could be project related creditors who might not be there in the books of accounts, who might not be recorded, because in ongoing project, if you are aware, some of you might be doing, we have to place the bill after particular completion, then they will raise, then they will release the payment, then you do some part of the project, you raise, do MB, MB, that is called material bill or something, then you get it signed by the executive engineer, your bill is passed, your amount is released. So that way it goes on in the project. Now in project there are related suppliers. Now if you make them the operational creditors like normal way and you provide very little for them, you will have a practical difficulty. They will not support you in the project, you will not be able to complete the project. So your risk of liquidity damage for the delay in the project, even your amount will be hold up, you will not get the completion certificate. So whole purpose is gone. So and it is an ongoing project, so there is no problem. You what we generally do, get it minutized in the this thing, key anything, this project is a separate in unit. Whatever inflow is there from the project, that will be used to run the project includes payment of the creditors who are doing the project. So they would not be treated as a operational creditors. So if you get the bill from a contract, government contract, and your amount is released and you do not pay the related creditors, then you cannot run the project. Okay. So it is better they do not file any claim. You treat this as a going project, and you make their payment out of the inflow from that project only. Okay. Sometimes, so what I say, maintain a separate account for the running project. Receivables and payables from that project has to be part of that project. And whatever net is there, that becomes the kitty of the resolution or the financial cater or whatever was there. And out of that, you can mention run the CIP process also, CIP cost. Sometimes a company, your the CD might be a lem lending. Suppose there is a escrow, they sometimes big contractor deploy a subcontractor, and this thing is that whatever comes in from the project, you execute the project, you make the vendor payment and all that. I will take a 25% or 20% cut because of lending my name, because the credentials of that company could have been used. So in that case, it is easy. The money generally might come net of the that way the subcontractor payment, or it will come in a escrow account. Out of that, your first obligation is to make 75% to the subcontractor, and this 25% is comes to the kitty of the creditor. So you don't make any payment to the vendor, so you are well protected, and then that becomes your amount. Then out of that, you follow whatever the IBC says. So for a running EPC, always strategize in that way and get things minutized in the COC, so that you are protected and make a strategy how you run the project. Okay. So this is one thing. Now electricity dues, and just very small. See, electricity dues is like other operational creditors. Only one, but for particular point, I just wanted to say. But in practically, what happens? Electricity departments, they make a nuisance, mischievous, and they don't give electricity connection. They hassle the successful resolution applicant in resuming the operations of the factory. In Calcutta, DVC has filed Damodar Valley Corporation, hydroelectric supplier. They are filing Section 7, Section 9 in many cases. Uh, a, a typical situation is that there could be an existing purchasing power agreement for high load with the corporate data. So that purchasing power agreement will be difficult to continue. It is not by law, it is just by that they have apparent, they will not give you connection. What I have seen in practice, some of the SRA, what they did, they give a fresh deposit. That could be a huge amount, could be 1 crore, 2 crore, 3 crore. But just to avoid the litigation, they do a fresh purchasing power agreement with the deposit. And if the electricity department gets some deposit, then they are more or less practically practically accepts the situation. And then you prepare a new fresh purchasing power agreement. I am talking about from the perspective of the successful resolution applicant, and you start operating. So this is the practical solution of a situation. Otherwise, electricity use is nothing more, is a more or less a normal operational cost, operational debt, and it can be treated. But sometimes practical things happen. I have heard from many SRA, sir, I have taken the company. After that, I find it difficult without making the past dues. They are not allowing me to resume the operation, and past dues might be huge, which actually under CRP should be dealt with in the resolution plan only, and a balance amount should be extinguished. But practical difficulties there. But during the CIP process, if you are availing electricity department, you make no mistake to make the payment so that they keep on paying. And believe me, I have almost 50% or 60% of the cases, I have a very difficult time with electricity department because generally electricity is cut, and they again we have to make them understand that during the past dues is a past due. You have to we will pay you the current dues, and they then they give in one case I have to move to the court, get a direction from the court and all that. Those things happens, and generally they will be on their toes, or they will keep you on your toes if 1 month or 2 month delay is there, because CRP cost to get it funded from the COC, it is difficult. So if there is some delay, they will disconnect, and then you again and after one it is disconnected, it is very very difficult to get the connection resumed. So just try that electricity is there during the CIP process, because this is a CRP cost only. Now, interest on invoice, that what I was discussing. So Supreme Court position is that there is a pre-existing dispute regarding the principal debt or interest. Section 9 petition is not maintainable. So only even interest के ऊपर अगर कोई there, if there is a dispute, so that also can be taken as a dispute of the credit of the debt, and in that case section 9 can be disregarded. Now there was one question initially ki, if there is an accepted invoice, the invoice interest clause printed on the invoice and not disputed by the corporate debtor, that means he has accepted or there is no dispute in that invoice stipulate interest and accepted. If this is a situation, then okay, contractual position is established by this acceptance of the invoice, then you can claim it, accept invoice. Otherwise, if it is there is a statutory authority, MSME Act, that will also underline. Otherwise, what we do in general, we take a section 80 where there is nothing stipulated. We take a 18% interest on the amount claim, and we generally, I as a RP, I generally keep admitting the interest at the rate of 18% on the operational debt. If there is a controversy of interest and all that, those kind of things there. Now, Supreme Court situation that we always, I think most of us know, Ghanasham Mr. and this, if something is not after the plan is approved, the claim is there, plan is approved, whatever is provided, nothing beyond that, nothing is there. Because as a RP, we keep on receiving emails, sir, my dues was 1 crore. Under the plan, I have only received 15,000 or 1 lakh. Please arrange for my balance amount. So we have a straight this thing. Company is under resolution. It has been resolved. So and your balance amount has been extinguished. And in general, all the resolution plans have that clause that whatever has been settled through the resolution plan is final. Beyond that, there will be no, and the balance debt is extinguished. That is there. Now, this was my this thing, what I wanted to communicate. So, what the clue is that the EPFO department claim has to be assessed initially very, very rigorously, gratuity claim. Though, yes, someone already was mentioning there is no legal position, but it becomes difficult because we have to make the communication to the banks and all that. That see, this is the amount that has to be distributed. And one more thing, the amount that is the workman dues under section 53, 2 year salary, not the employees, it is workman, which is pari passu with the secured creditor. Employee is normal operation creditor, that are at par with the secured creditor. You have to be very careful what is the amount of impact. You have to make preparation accordingly, and you have to mention the resolution applicant ki either you provide it within the total amount your plan, or you keep a provision to bring it separately, that so that it is
Here,
provided.
I would like to bring to, because you are referring my issue, I would like to bring to everybody one important aspect. The EPFO department doesn't like to be treated or categorized as operation creators. They specifically mention that they are not operation creators, they are only other creators. They have given in writing to me, stating that as per so and so judgments, we are not operation creators, and they have submitted claim form for other creators. That format, in that format, only they have submitted. So there is so much of clarity is required, sir. So much of
Yes,
clarity,
yes.
legal clarity is
and
required from EBA in this aspect.
and
Particularly from EPFO, there are so many things, so many complications are there which are very much contradictory to the IBC.
Mr.
So
Raju, I just want to share one more thing just to add you. Even there are judgments. They have shown judgments in one of case. They don't file any claim form. They will just write a letter with an amount. This is the amount due, and once
yes,
this is written, yeah, that is the priority date, not an operational date, not a financial date. It is a priority date as is provided. So that is the practical difficulty. I have held a situation where they have just given an amount determined, not in a form, in a letter form. Yes, that amount was up to the insolvency commencement date, but that was not in a particular form. They say we are not required to file a form also as well. Yes,
yeah.
that
They
is
did
the
that. They were not agreeable to sign that even affidavit.
yeah,
They were
yeah,
not
yes, yes,
ready to
yes, yes,
provide that affidavit so that has to be
uh,
attested in the form at the end of the claim
yes,
form. They
yes,
have
yes.
to attest it. They are not interested. We are government
Yeah,
authorities who don't require any attestation. We
and
don't any
they
format.
find it really, yes, right, they find it pleasure in in getting taking this high handedness in a CRP process. It is a kind of pleasure also that money. As of now I don't have
What
right
I
answer.
require is when such a they are doing for social security of their work, for their employees. They are doing that they, as per their statute. We don't we should not dispute with them. But there should be a clarity from our regulator. When
Yeah,
so many queries
that
are coming, so many case laws are coming against the IBC itself, why don't they form a separate regulations for EPF regulations like that? So many regulations are there. You give us clear cut guidelines, we will follow that. So the point
fine.
is, yesterday some case has come which is saying that it is the section 53 is subject to EPF claims. Day before yesterday, some other case would have come with some other high court stating that EPF claims do not have any prior to our section 53. Then which we have to take into consideration. We cannot go around to all the high court cases of all the 29 states of the country, which is the latest
Yes,
one.
yes, 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 I agree that that is the situation now. There
See,
is one question.
leaving us to the employee liquidation or IP is not that much of legal evident person. Then we
Yes,
should
yes,
be guided by the regulator when cases of complicated nature are coming out day in and day out, and courts are very favorable to the EPFO. Then why our regulator is not coming out with specific guidelines, regulations? That is main problem.
yes, yes, yes. I agree. I agree. Now there is a question from Mr. Shekhar Sengupta. If purchase order earlier released by the CD does not mention interest clause and the invoice upon supply mentions standard interest clause, will interest be applied along with the principal dues in case of OC subsequently takes the CD into CRP? Now, yes, this is a case which I, as a RP, I would not admit, because yeah, there only they have mentioned a general clause in the interest, and it is not accepted. It is not accepted interest. So this is an open area. If I am the RP, I will reject it. And if if I am filing for corporate data against that section 9, I will say that this is not an acceptable interest to be uh, included in the amount of claim or amount that eligible for admission of a CRP case. This is to me, this position is clear based on the legal position as of now. Okay, so I think this what I wanted to know. If any other questions there, otherwise, from my presentation point of view, whatever I wanted to say, I have shared.
Uh, So any more questions, sir, from the participants?
So actually, I have one question. In case of COC or a liquidation, only the operational credits are there, and they are not making any payment for any that process. Okay, so that type of situation there when operational creditors are only there, no financial creditors are there. So how to deal with this situation?
Here also, these situations are typical situations, and you believe me, it is without the court, you don't get any help. You don't get any. I have seen RP getting frustrated of these kind of situations. So they are actually you have to go to the court, and either you have to ask to release me, or you have to instruct. You have to give the court petition that to instruct these people to make your payment. So apart from that, there is no other situation. And this is
But
a I mentioned in my presentation also, where COC is with only OC. Generally, they don't pay.
uh, so whether NCLT has is there any order that NCLT is asking them to pay, or they say that we are also unable to ask them or something like
That
that?
I have to check. I know petitions have been filed. That I have to check. If I can find out, I'll just definitely I'll
Okay.
just try to
Because
inform.
in case of because I also the asset is with PML and I have to make a petition to the court, and then there are not a single money they are giving it. That is the problem also.
You immediately see whether there is a case law. You immediately file a petition to the NCLT
Hmm.
asking for a direction on the operation creditors to arrange for the CRP cost. This is the
Okay.
first thing you have to do, irrespective
Okay.
of whatever whether there is or not. That is the practice.
Okay. Thank you.
Sir, there is one more question from Mr. Manish Jaju. Is asking, do we require GST returns to verify claims? Sir, you are on mute. You are on mute. Pratik,
Sorry,
sir.
GST. Yes, GST returns is an additional document, and if you have any kind of doubt that is something, you can file with the GST return also, whether the amount that has been sold, the invoices have been included in their return. So that is an document, and if you have some doubt in your this thing, see, generally you will go to the books of account and all that. So it is an additional document, and if there is any discrepancy, you can always rely upon either for accepting or rejecting the GST return for the claim.
Sir, I would like to add here one thing. Sir, in resolution or liquidation, we are in the almost in the nature of a adjudicating authority. We can ask anything because depending on the situation, not in every case, we may ask other documents also. It is for our satisfaction, we will ask, no, and they are supposed to submit. Regulations also provide for submission of the proofs. If you require further proofs, they are supposed to submit.
Yeah. You can ask for document. Actually,
Yes.
we are not adjudicating authority. We are by the law, we are collating. But if you have any doubt, you can ask for supplementary documents. That is no
In
doubt.
liquidator, you will admit it. In liquidator, you
Mm.
are admitting, and for in CRP, you are collating it. In
Yeah.
liquidator,
That is true.
your duty is more like an like a adjudicated authority. Adjudicated
But
authority
okay,
can ask anything. They can ask anything to
uh,
the satisfaction.
now
That's
there is
like
one more question. Is gratuity in full applies to employees whom RP considered for assisting him in CRP, or all continuing employees as on ICD? What about the employees gratuity issue for those who retired prior to the ICD and not paid by the CD as on ICD? See, accrued and due in gratuity accrued on due as on the insolvency commencement date, and if it is filed as a claim, it has to be paid in full. So whoever has retired before the CRP date and their gratuity remains unpaid, so it is coming under accrued and due on ICD date, and it has to be provided full. There is no doubt about it.
Right. Okay. Thank you.
While accepting operational caterer, if claim if there is a supporting documents are not available, then can we say how long we can say that under the claim is under verification?
There is no limit. If you are not satisfied with the document, the claim is there is nothing underlying, you can keep it under consideration. Yeah, the CRP process, you can keep it, no problem. You has to be satisfied that there is a claim exist. No problem.
Okay. But under verification we can maintain that.
Under verification, you better you reject it. Now what is the point in keeping long? If you give a stipulated timeline, ask for document. If they do not file, if reject it, don't keep it open for long.
Make
Theoretically, you
correspondence.
can, but
Make correspondence, sir. Keep the correspondence with you.
uh,
Keep the
yes, yes.
correspondence with you.
Within
Okay.
7 days, you revert. You give a date. Within 7 days, you revert. That timeline is 7 days. 7 days, you revert. Ask for the document and give a timeline. Maybe one or two times. And if they don't give it, you reject it.
Yeah,
Simple.
but we cannot verify from the books of account of company as I mean, this corporate data as such. So
That
that
is that. See, that depends upon case to case. If you are asking for some separate document, you must be having some logic. Now that it depends upon pure commercial issue. What is there? Some claims are obvious. Some claims are doubtful. So that you have to judge.
Sir, regarding the gratuity, I also have a doubt, sir. In our case, the company had around 3 crores of gratuity fund, whereas
Mm.
the gratuity payable as on ICD date is around 4.5 crores. So,
Yes. So yes, yes. So the one point, the 3 crore is protected. 1.5 has to come from the either CRP kitty or from the liquidation estate, whatever is the stage. So 4.5 crore has to be paid. 3 crore will come out of the gratuity fund that is there, and the balance amount either from the kitty of the assenting financial creditor and all that. So you have to make a full provision.
so gratuity has to be paid in full, 4.5
Yes,
crores.
yes, 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 yes. 4.5 crore, 1.5 crore has to be arranged. Either RA will keep in separately, or he will tell that it will be deducted from the ascending financial capital, whatever is there. But 4.5 crore, if you have admitted, that has to be paid. 3 crore is protected from the fund. Balance has to be paid.
Okay. In case if SRA is not providing, it has to be from the financial creditors entitlement.
SRA providing means SRA not providing separately. It has to be and you make the resolution plan. You being an RP, you make the resolution plan explicit on that way. You make everyone aware this is the situation. Otherwise, your plan will be stuck. It will be again sent back to COC and all those things.
Sir,
Okay.
I
In case,
have two queries. Udayraj Patwardhan here.
okay.
Regarding gratuity, sir, I have a submission that if the company is continuing and the full value is of the gratuity is recorded in the books recognized by the SRA, why should it be paid upfront? It can be continued in the books as payable if those employees are not living. That is my
No, no,
first
no.
query, sir.
Uh, no, no. I tell you, it is I what I have told accrued and due, accrued and due.
Yes, yes, agreed,
If
agreed, sir, agreed, agreed,
so,
agreed, sir.
whatever is due, accrued and due, not accrued amount. Yes, no, no. If no, someone is continuing, why to pay the gratuity? That is not accrued and due.
Yes,
See,
sir.
see,
And
I
no,
tell
agreed,
you.
sir. Due and payable has to be paid, no doubt about it. Another query, sir, I had about the EPFO discussed a lot. So according to latest judgment, I just had an occasion of dealing with EPFO last week only. So they understand that penalty and damages, ROC, and everything else is priority. They understand, but they don't acknowledge. But that is how it is. We have to keep a watch on latest judgments of NCLT, NCLAT, because even the Navneet Kumar judgment, which was very valid 1 year ago, is today not valid. So things do happen, and we will have to keep a watch on that, sir. You are correct.
Yes, yes, and as long as a penalty and interest, we have to find out we have to see very categorically, methodically in the in the claim what is the amount of penalty and interest, whatever that you reject, and the plain due of APFO has to be accepted. That is the reject means you can accept in the form of penalty, but provision has to be only for the amount, pure PF amount, not for
Right,
the
sir.
penalty.
Right, right, sir. Thank you, sir.
So there is one interesting aspect that has come in my one of my IP friends case. He is liquidator of one assignment, sir. Sir, am I audible?
Yes, you are audible, sir.
Yeah.
Yes, yes, you are
And
due.
there was only little amount of recovery under Section 53. He has sold away some assets and it has yielded amount 15 lakhs. That was the amount yielded from Section 53 out of the liquidation estate. Now,
PF amount is
CRP
less.
cost, first thing is CRP cost and liquidation cost should be paid. Now, CRP cost is 20 lakhs, so liquidation cost is 20 lakhs. Now, he has received only 15 lakhs, which should be paid first.
So
either liquidation cost.
better file an application to NCLT in such cases rather than taking risk. I have,
No, no,
Mr.
no,
Raju, I
no,
have
no,
heard
no.
you.
Mr. Raju, just 1 second. Mr. Raju, what is your question? Your distribution amount unpaid CRP cost or liquidation cost or
Yeah, yeah.
yeah.
Unpaid CRP
So
liquidation.
unpaid CRP. See, it's a simple logic. What I know, what is this thing? Acha, now if nowadays generally RP are different and liquidator is different.
Yeah, yeah.
In a case where RP and liquidity is same, so it is no problem. See, logically the CRP has happened earlier. Okay, so unpaid CRP cost is forming part of liquidation cost and it has to be paid. But yes, if there is a different person, if I have worked and I don't have anything, then yes, it is difficult. Then you have to. Acha, one more thing, unpaid CRP cost, yes, if it is already determined, because liquidator fee can be different kind of thing. Liquidator fees can be, uh, the table is an indicator. The SCC
Yeah,
can give a different kind of, they can fix,
yes,
they can
yes,
arrange. And in that case, I think SCC also can help out what to do, because SCC is generally the continuing the same body. They can also help out.
yeah,
And worst case, what Mr. Patwardhan I was saying, we can go to NCLT, because this is the situation. If the total kit is less than this thing, we have to take, or a commercial decision with the commercial creditors, and that can also be discussed. It's a typical situation, right?
yeah, yeah. Okay.
Thank you. Thank you, sir. Hope we have answered all the queries from the participants.
Yeah, good evening, sir. I have one question, sir.
Yes.
See, there is a situation in this case, in my case only. The earlier I was a RP, my resolution plan is not approved by NCLT and the company went into liquidation. Some other person has been appointed as a liquidator and my CRP cost is also unpaid. Now the other person appointed as a liquidator also, he resigned because there is no assets in the company. So he realized, and ultimately court appointed me as a liquidator. So my now what in that situation, my CRP cost as a RP is also paid, and now the liquidator cost is also paid. So what to be done? Or
No,
some
your
amount.
your unpaid liquidation cost is unpaid CRP cost is a liquidation cost. Okay, liquidator fees, liquidation cost. The definition of liquidation cost includes unpaid liquidation fee, unpaid CRP cost. So your fees, whatever is eligible and all, it is there. So what is your difficulty? You don't have fund to pay.
There is no assets, only the SRS deposit which he has given at time of submission of plan. That is only pending, and that is very small amount.
So that's the commercial issue that you have to ask for the SCC to help you out if they pay, or else you have to go to the NCLT. This is a commercial issue. You don't have the fund, which is the more than the dues, the cost, the unpaid CRP cost, the liquidator fee is more than the amount which has got realized. So in that case, SCC has to fund that amount. I have handled one case where there was nothing, but initially it was getting understood. So initially I have told SCC to provide some fees for me, and there is a provision also that if the liquidation expense, meeting liquidation expense is not possible from the liquidation estate, then the financial creditors has to provide for the amount of liquidation cost. Okay, that is there. By that, I got some fees. Definitely, it was minimum fees, but I got some fees. So that way, you can talk to them. Otherwise, the court is court is the process. But generally, if these are banks, they give some fees to conclude the process. They don't. That is not that bad situation.
Okay, thank you.
So there's one small question. Will the gratuity payment be paid before the CIRP expense is paid off to the IRP or the RP in the team?
No, CIRP expense, you can make a provision in priority. After that, you can pay gratuity. That would not be an issue.
Okay.
CIRP cost, you can
So
first pay.
gratuity and
In fact,
PF payment can be post the CIRP expenses being paid. That should be
yeah,
right.
because see, here, yeah, here, because in general, if there is a resolution, these things are easy to handle because there is a specific amount. You know what is the CRP cost, what is the gratuity. You make the plan that way and provide these things. These are difficult in a liquidation situation. In CIRP process, it is not a situation. You can pay the CRP cost and then pay the gratuity amount. You must have provided those amount in the resolution plan. That is generally not an issue.
Okay, sir. Thank you.
Sir, if I may, I would add something to the query. Is in such cases as to what payment to be made earlier, any questions come to the RP? If there is a question of making an error, RP should make an error on the side of caution. So if we feel it could be paid in advance, you tell the SRA you pay in advance. Don't work as an advisor for an SRA. You will get in trouble. If you want to make mistake on the side of caution. Don't go and try to interpret law that will benefit SRA and that will hang you at some point. Let them take legal advice. Let them do whatever they want to do. Don't advise on such matters unless you yourself are an advisor. Otherwise, as an RP, if you want to make mistake, make it on the side of caution. That is the only suggestion I will give at this point.
Okay.
So hope today almost all the participants had the questions, and we had an excellent speaker, Pratim sir. So a one-line reality check is that operational creditors have the right to knock the IBC door, but once inside, they stand in the back row. So
That is also there. That is the reality. Actually, generally OCs, but filing the rejected or the withdrawal section 9 petition also yielded a high amount. That we all more or less we know that petition withdrawn, section 9 withdrawn has also satisfied this thing. That is the target actually by section 9, unless something else is there. Otherwise, generally OCs have realized also as a group. I'm not talking about particular OC. Yes.
So we had an excellent practical session, sir. You have almost shared all your experiences and also whatever queries practically our IPs are facing. You have given your views and suggestions, and we also had Udayraj sir and others. Thank you very much. And sir, thank you for accepting our invitation. And it was really an enriching session for all of us. So on behalf of IP, we are sharing this certificate of appreciation.
Yeah, thanks to the IPNet community, and it is an enriching experience for me as well, because it is, I always say, it is an interaction apart from giving presentation. So interacting with the fellow colleagues is also gives enriches my experience, and that's why I always gain whenever I give some. I have given around 25 to 30 such this thing in IBBI platform, in IPA platform. So it, for me also, it gives some enrichment to my knowledge, to my experience also.
Thank you, sir. Thank you very much. So we will have one more session that is on the same topic, but sir has extensively covered entire completely about the operational creditors' rights and their strategy, and also he has touched upon some very important concepts and regarding the operational creditors. So I'll just try to share only very few recent case laws. I'll just share my PPT. Priya, can you confirm whether my presentation is visible?
Yes, ma'am, it is visible.
Is covered almost concept of operational creditors. So in my PPT, I wanted to cover the definition and scope of operational creditors, and also pre-admission stage, what is the role of OCs regarding the corporate debtor, and also post-admission, how the claim is filed, and during the process, how a COC is constituted, and in case operational creditors are there, and with financial creditors getting the voting rights, how the OCs have to influence the resolution plan. And as per the section 30, what is the minimum payout payable to the operational creditors under the resolution plan? And also, I thought I'll just discuss few challenges regarding the delayed payments or rejection of disputes, rejection of the claim of operational creditors. So mostly a lot of things, sir has thrown very good practical insights on all these things. But I'll discuss more about the recent jurisprudence on the operational creditors and their treatment in the resolution plan. So, in recent case in NCLT Mumbai, Sanjay Dayanand Sachdev versus Dinesh Kumar Diora, where without the essential and requisite documents, RP has admitted the claim. So, it was challenged by the financial creditors, where the NCLT has held that without the essential and requisite documents, RP cannot admit the claims of the operational creditors. So we have one more important case, that is Visa Coke Limited versus Mesco Kalinga Steel. In this case, the Supreme Court has addressed whether the service of statutory demand notice under Section 8 before admitting the Section 9 application, if the notice is served to the KMP, not to the corporate debtor, whether it is a valid notice. So NCLT and NCLATs have dismissed the Section 9 petition on the ground that it was not served to the corporate debtor, whereas it was served addressed to only the KMP of the corporate debtor. Here, Supreme Court has held that the KMP address was the corporate registered office, which satisfies the statutory requirement, and hence Section 9 petition is maintainable. Here, Supreme Court has emphasized that procedural defects should not defeat the substantive rights. So, NCLT and NCLAT orders were set aside, and Supreme Court has remanded to NCLT for fresh decision on merits. As we all know, this was the last year's most discussed landmark Supreme Court case of Kalyani Transco. In this case also, there are two petitions where the operational creditors have filed challenging the approval of the resolution plan. That is Jaldi, it was an operational creditor who was holding an international arbitral awards. They challenged their classification of their claim as contingent creditor instead of a crystallized operational creditor, because of which their recovery has drastically reduced to 10% versus 50%. So here the court has noted that the operational creditors' inconsistent stance. At one point they were claiming that they were the contingent creditor, and later they were claiming as a OC status. So hence, considering the both the versions from the operational creditor, because the matter was also the award and the arbitration award, and the matter was before the Calcutta High Court. Here, the COC has classified the operational creditor as a contingent creditor based on the commercial wisdom. So here, Supreme Court has held that they will not interfere with the commercial wisdom of the Committee of Creditors in classifying the claim of the operational creditor as contingent claim, sorry. So one more was there are two operational creditors. They raised contentions regarding their claims relating to the pre-CARP dues. Here the court has held the payment related to pre-CARP dues must strictly be followed as per the IBC, and if the resolution plan provides any specific way of handling that claim, that has to be followed, and no new question of law has to be raised in the appeal. Hence, this claim of operational creditors was, their contention was dismissed. So this one of the participant was asking about the interest portion on the MSME, interest by the MSME. So here in this case, I wanted to discuss about this when sir was asking about the question of interest portion by MSME. So here it was held that the interest portion has to be dealt under section 16 of the MSME Act. It cannot be, the appropriate forum is MSME Facilitation Council, and the correct forum is MSCFC, that is Facilitation Council, and it's not NCLT. So here NCLT Mumbai has held, if interest is not agreed between the parties, it cannot form part of the operational debt in the under IBC, and that interest can be claimed in an application under, and that interest which is not agreed cannot be claimed under section 9 application. So here NCLT Mumbai has held that the code cannot be used as a recovery mechanism or as a substitute for debt enforcement procedures. So this already, I think sir has discussed about the whether the purchaser of a property qualifies as an operational creditor. So here the tribunal has considered whether purchase of a property could be categorized as an operational creditor. So operational creditors are individuals even or entities whose liability towards the organization arises from transactions related to operations. So here the lessor from whom the organization leases space is classified as an operational creditor. This is regarding the debtor owning a monthly rental obligation for duration of 3 years. So here what happened, the petitioner has failed to furnish the commodities or services necessary to qualify as a operational creditor. So as we all know that the to get the application admitted by the operational creditor, the NCLT verifies whether there is a pre-existing dispute between the parties before issuance of the demand notice. Here in this case, what has happened, the operational creditor Krishna Construction Company, they have filed an application under section 9 before NCLT New Delhi seeking admission of CRP against the corporate debtor, that is New Era Solutions Private Limited, for default in repayment of relating to the bills under a work order. So here the operational creditor has issued a demand notice. Then the CD replied to the demand notice referring to an arbitration notice which was already invoked prior to the section 8 demand notice. So here the NCLT dismissed the section 9 application, holding that a pre-existing dispute existed between the parties prior to issuance of demand notice. But again, on an appeal, NCLAT held that initiation of arbitration proceedings prior to section 8 demand notice is sufficient to establish a pre-existing dispute. So even the appeal was dismissed. Then we have a few important case laws which are like Mobilox, Mobilax Innovations versus Kirusa Software, where it was established that a pre-existing dispute or any pending arbitration can prevent initiating CARP process. Then again, one more important recent ruling in Greater Noida Industrial Development Authority. The court has held that claims filed in the wrong form should still be considered if supported by a proof. If the claim is not submitted in a correct form, which is prescribed by IBBI under CRP regulation, so even then, if the claim is supported or substantiated by a supporting document, then that has to be considered by the IRP or RP. Then, as we all know, Swiss Ribbons has, the Supreme Court has held that there is a differential treatment between the financial creditors and operational creditors. And this was justified the exclusion of operational creditors from the Committee of Creditors. But again, the judiciary has, in many cases, they have held that although this is discriminated, but their hands are tied because if you see the BLRC report, it is very clearly, we have a very clear bifurcation of treatment of operational creditors and financial creditors. So even the judiciary cannot overarch on this. So they have clearly mentioned that until the legislature comes to the rescue of operational creditors, they have abide by the code and the regulations made. And even if operational creditors challenge a resolution plan, they cannot challenge the commercial wisdom of the creditors on approval of the resolution plan until and unless the plans are fair and equitable treatment. So this was again held in the SR Steel. This was upheld in SR Steel, the commercial wisdom of the COC in approving the resolution plan. So even if we see Supreme Court of Vijay Kumar versus Standard Chartered Bank, even the operational creditors are granted the right to receive the COC documents, including the resolution plans. This is again that limit as per the regulations. It is overall the admitted claim is 10%. Then the operational creditors has to be invited to represent one of them as the representative in the COC meeting. So the RP is duty bound to send the notice, agenda notes, and all the relevant documents relating to the COC, including the resolution plans, all have to be shared to the representative of OC in case the overall debt admitted, the entire debt admitted is if the operational creditors debt is 10% of that admitted claim. So in many, as I was discussing, in many cases, the NCLT, NCLATs have held that even the government has to examine and find out whether there are any grounds for changing the legislative scheme of things towards the payment to operational creditors, or otherwise, as per the code and the regulations, only the minimum liquidation value is payable to the operational creditors. So as we were discussing regarding the issue of notice to the operational creditors by the RP for the COC meetings, this is as per section 24 subclause 3, clause 3 subclause C. RP has to mandatorily issue the notice of COC to all the operational creditors if their admitted claim is more than 10%. So even if notice is not served, then the RP, in some of the cases, the NCLTs have referred the matter to IBBI. So this regarding the electricity board dues, sir has clearly discussed whether the electricity dues override the IBC waterfall mechanism. Here, many times the courts and even the Supreme Court in Paschimachal Vidyut Vitran Nigam, the court has clarified that IBC overrides the Electricity Act. So it has reaffirmed that government dues rank lower in priority. So the categories of operational creditors, sir was discussing about the kinds of operational creditors who all fall under this section 9. So in regarding the employees, if employees claims are more than 1 crore, their trade union can file a section 9 petition for admission of company corporate debtor into CIRP. And in this case, JK Jute Mills Majdoor Morcha versus Jugilal Kamlapat Jute Mills. In this case, the trade union has filed a Section 9 petition on behalf of 3,000 workers for unpaid wages. So here the key issue before Supreme Court was whether a trade union can file an operational creditor. So the Supreme Court has affirmed, saying that a person can be on behalf of the members, insolvency can be triggered by the trade union. So in one of the recent case, this is an exceptional use of Article 142 by Supreme Court. This was in Rajendra Narayan Sharma versus Amit Goyal. So here what has happened, CIRP has progressed significantly and claims were invited. But again, a comprehensive private settlement was reached between the operational creditor and the corporate debtor. So since the CIRP has progressed significantly, NCLT and NCLAT have denied the withdrawal of the CD from CIRP. And in this case, so Supreme Court went and exercised its Article 142 power, allowed the withdrawal through a statutory route. See, what Supreme Court has held is, to complete the justice, they have a overriding article through Article 142. They have the jurisdiction to provide the justice, overriding the procedural rigidity. So there is a procedural rigidity for withdrawal of company from CIRP. As per IBC, the COC with 90% has to approve. So IBC went and overrided the procedural rigidity in this exceptional circumstances, and where a genuine full settlement was achieved between with the creditor. Hence, the Supreme Court has allowed for withdrawal of CIRP in this case, even though there was no 90% approval for the settlement. So the main observation by Supreme Court was to save the company from liquidation. They have allowed this. Then there is a distinction between full settlement versus partial settlement payment. So what happens in case if there is a partial payment, then in that case, the adjudicating authorities nor Supreme Court, they will not allow for the withdrawal of the company from CIRP. So in this case of Saraswati Wire and Cable Industries versus Mohammad Moinuddin Khan, here a partial payment was paid by the corporate debtor. And there was an argument on the pre-existing dispute to stop the insolvency process. So here, Supreme Court has discussed the main key issue was whether partial payment constituted full settlement for withdrawal. So here, what Supreme Court went and discussed based on the facts is, here there is a clear cut between the parties that there is a pre-existing dispute. But again, however, it did not automatically lead to withdrawal. So this case was allowed to proceed as the full debt was not settled. Hence, here there was no full settlement, only partial payment was there. So that for that partial amount, there is a debt. Hence, there is an existence of debt, and Supreme Court has send back this case to the NCLT to decide on merits. So this is also one of the important recent case. See what has happened. The operational creditor filed a Section 9 petition. Here, corporate debtor has earlier marked the debt as dispute in information utility. So in NESL, as we all know, the debt has to be registered. So here, corporate debtor has registered the debt of operational creditor as disputed in IU. So whether disputed under IU constitute a sufficient evidence of a pre-existing dispute to dismiss a petition. So here the tribunal held that if debtor actively disputes a claim, it is a pre-existing dispute. So here even if NESL also, if it is recorded, if the corporate debtor registers as a disputed in IU for any of the operational debt, then in that case also NCLT will reject the admission of the CIRP process. So I just wanted to touch on latest case laws regarding the operational creditor. So thank you. Any questions? We can take it up. Or otherwise, most of the questions were answered by sir. Any questions?
Hi. Ma'am, if we partial payment, then in that case, the FA will be validity. Is that true?
Actually, there was some lag. I was unable to get your query regarding the partial payment.
Yes, yes, for 12A withdrawal.
Regarding the partial payment?
Yes, please.
Okay, so see what is there was a partial payment. That means the remaining part is not paid. So there is absence of debt, hence court has considered for admission.
Okay, so in that case, suppose there's an FA which has been received by an IP for any reasons, and should the COC be constituted in the interim till the time the NCLT passes an order, or should? Better now? Am I audible now?
You are audible, but your voice is not clear to me. See what?
Okay. No, just in case there's a form FA received by an IP for
may I add
withdrawal.
here something?
Yes,
Suhasini ji?
yes.
Yeah. In case of withdrawal application filed, the CRP continues. So COC formation, etc. will continue till an adverse or a order of stay is passed by the authority.
Right.
Now, in the first 1 month, say the settlement happens and Section 12A application is filed by the IRP with the NCLT itself. Still, unless there is a stay on formation of the COC will be formed, matters will continue, but that formation of COC will in no way be a hindrance for the 12A which is already filed. So COC may come in later and say that now COC is filed, take our approval also. That is not necessary. However, it will be necessary that COC may come and take objection in the 12A because of the Byju's judgment. Because Byju's judgment says that everybody should be heard who comes before the court.
Okay.
So though COC approval will not be needed, but if couple of creditors come and object to the withdrawal, the honorable NCLT will hear them out and may even reject the 12A also. That is a possibility. So COC formation is not necessary, but as I said, the objections can be taken by those creditors in the 12A by coming before the bench. That is a possibility. That is so far as 12A with NCLT is concerned. Sometimes the corporate debtors promoters run to NCLAT in appeal and they get their matter heard there and there is an interim stay. So when the stay is there, I would always advise the RP to be present in all the hearings and ask necessary questions before the bench as to what is the stay for. Is it for formation of COC or the whole of the process is stopped? Typically,
Okay.
NCLAT would give a stay on formation of COC, nothing beyond. So the process will continue, claims will be accepted, list of creditors will be prepared, but
Hmm.
COC will not be constituted. So
Okay.
that is if such a stay is given by Honorable NCLAT. If they do not give
Okay.
any stay, then the process will again continue. And if
Hmm.
COC, once it is formed, then
Hmm.
the 12A will have to go to the COC for its approval
Okay.
because it did not get filed before the formation of the COC. So in the first example I gave, the 12A was already filed with NCLT and then COC was formed because there was no stay. 12A quickly came to the IRP say in 15 days time and before the
Hmm.
end of the third week, because on 23rd day we for constitute the COC. We don't constitute COC on 30th day. We do it on
Right.
23rd day. List of
Right.
creditors prepared on 21st day. So
Yes.
before that, if 12 is filed, no problem. But if you go to NCLAT, NCLAT doesn't give any stay order, 2 months
Hmm.
pass, so the
Hmm.
COC must have been already formed, and then 12A will have to go to the COC for its approval.
Okay.
Third situation is you go to NCLAT on say 5th day, NCLAT gives a stay on 15th day that COC should not be formed. Settlement happens. Thereafter, NCLAT would say, okay, withdraw the appeal. Then typically the order is the IRP to go back to NCLT, file the application under 12A
Hmm.
and COC not to be constituted till 12A is decided. Such orders
Okay.
are now very normal. I have such orders in my cases also. So such happens, then the 12A is completed, but COC is still not formed, even in 6 months, because there is a specific stay by NCLAT. So unless there is a stay by any adjudicating authority,
Hmm.
COC must be formed.
Okay. And even if it is the form FA is very specific in IBBI. If the form FA that the RP receives or IRP receives is not in the format in which it is mentioned in IBBI, that is, the bank guarantee is not
It has to
provided
be
for
in the
CIRP
format, it
cost.
has to be with the bank guarantee. You can write back to the applicant that you provide the bank guarantee as required, or you pay everybody out. Either of the two is fine.
Right.
We told, but probably not in writing, and they have
No,
put it in the.
everything is not in writing is not said.
Okay.
You cannot take it to the
Okay.
adjudicating authority without
No,
the.
no. RP, this is the only opportunity with the IRP to recover money. Afterwards, if 12 is withdrawn, you will run after your money. You will never get money. I am telling you.
Yeah, right, actually. Because in the prayer we have actually put in saying that, please,
No, that is
reimburse the
not correct.
cost.
That is not correct. That is not correct. Then if
Okay.
money is not paid, then the RP should not cry that my money is not lost.
Very well. But
Thank
and
you.
even
Sorry, we
if
went little.
partial settlement has happened, it's as good as no settlement, right?
No,
Suppose
no, come
100 was
again.
payable. If partial settlement has happened, suppose the dues were about say
No,
100.
settlement is an agreement. Settlement is not full payment.
Okay.
Settlement can be I will pay you in 5 years also.
Okay. Okay. Got you.
Settlement is an agreement that we have settled our dues to be paid off in a particular way. For example, I
Okay.
will tell you, there is a standard account with the COC. And in
Hmm.
the meanwhile, some OC gets its Section 9 admitted. Then the
Hmm.
COC may say, okay, you continue to service our accounts as it is because I am standard everywhere. Only
Okay.
Section 9 will be settled in full, maybe. Or there
Hmm.
could be installments also. So that is not a problem.
Okay. Done. Got it. Thank you
Full
very
payment
much.
is not necessary for settlement. No.
Fabulous. Done. Thank you.
Thank you. Thank you. Sorry,
Thank
sorry, we went little outside the OC matter, Madam Suhasini ji. Sorry.
No, sir, you have answered
you, advisor.
complete answer till the filing. Thank you very and so it was such a wonderful, even though 26 or 20 participants were there, but each one of you have participated with query. We had an excellent session with Pratim sir. and Udairaj sir pitching in for answering all the practical issues. Now we have Advocate Ria who will be sometimes on behalf of IPNet. And next week, please do join for IPNet East.
Good evening, everyone. It is an honor to extend the word of thanks for today's webinar. Today's event has been a good learning experience for all of us so far regarding the resolution plans, practical issues. First and foremost, I extend my heartfelt thanks to our distinguished guest, Speaker Shri Pratim Bayarji, for sharing their profound insights on a very critical and practical concepts in IBC. We are very grateful to both of you for sharing your time, wisdom, and experience. I would like to express my gratitude to our IPNet President, Mr. Ashish Makhija ji. Ashish sir, your commitment and visionary leadership have made IPNet an explanatory initiative and a platform of great significance for insolvency professional pan India. Thank you for being a guiding light to all of us. A special note of appreciation goes to IP Net South for successful smooth conduct of this webinar. Special thanks to the invaluable contributions of transition and technical support teams. Their seamless coordination, tireless efforts, being the scenes in short, smooth conduct of webinar. A gratitude to all the participants who joined us today. Your enthusiasm, active engagement, and thought-provoking contributions have truly made this event special. Thank you, Suhasini ma'am, for your great knowledge or sharing knowledge session. Thank you to all once again.